Mr. Clement, is this case distinguishable from free enterprise? It seems as though we've been down this road.
We don't think it is distinguishable from free enterprise, Justice Thomas. Obviously, some lower courts have disagreed with us on that. But I don't think there's any material basis for distinguishing the two, especially when you look at the nature of the claims here. The nature of the claims here are structural claims. They go to the very existence of the agency, and those are wholly collateral to the merits of any acquisition. Those claims are beyond the competence of the agency, and the agency is not in a position to provide meaningful relief.
Could you take just a minute to set out just more specifically why the agency could not consider these constitutional claims within its structure? I think you'd have to start by saying what it actually does and what would be reviewed at the appellate level after the agency issues an order.
Sure. So if you start with the typical case where the agency builds an administrative record that informs their position on a particular transaction, all of the claims here are sort of cross-cutting or maybe even logically anterior to any of that process. One of the due process claims goes to the clearance process by which a transaction goes before the FTC rather than the Justice Department. And that claim obviously doesn't really focus on FTC agency action, but it focuses on executive branch action that's beyond the FTC. And then as to the more structural claims, I mean, those are beyond the competence of the agency for two reasons. One, no agency has the authority to declare itself unconstitutional. But if you think about the double for-cause removal restriction on the ALJs in particular, I mean, the most logical way to remedy that violation, at least following the logic of free enterprise fund, would be to declare the second layer of for-cause removal provisions unconstitutional. But that second layer of provisions is in Title V, 5 U.S.C. 7521. It's not in the FTC Act. So the idea that the FTC could declare another act of Congress in a different title of the U.S. Code unconstitutional is completely beyond its ken. But of course, that's exactly what district courts do on a day-to-day basis, exercising jurisdiction under Section 1331.